Let's go ahead and get started. Welcome everyone to the March APDU webinar. I'm Beth Jarris, Senior Program Director at PRB and Vice President of APDU. And we are joined today by the delightful Danielle Hirsch, Managing Director at the National Center for State Court Access to Justice, and Zach Zarnow, Deputy Managing Director at the National Center for State Courts Access to Justice. And they are going to talk to us about state courts and using data for good. So without further ado, I will turn it over to Danielle and Zach.
Thank you very much. We're thrilled for the opportunity, and we're really grateful when Amy O'Hara reached out to us. So thank you for the opportunity. Because we are a relatively small group, we'd love to make this as informal as possible. So as we're going, if you have questions, you should feel free to just unmute yourself and ask them. And hopefully we can have this be a dialogue, or if you prefer, you can put it in the chat and we'll monitor both the chat, and also happy to be interrupted as we go. What we thought we would do in order to begin was to give a little bit of an overview about state courts and the kind of data they collect, and have a conversation about that, and then pivot into some of the ways we've tried to increase access to information or promulgate best practices, and then hopefully open it up for even more dialogue and discussion with all of you. Before I'm going to start about what is state court data, but before I do that, let me just explain a little bit about the organization that Zach and I work at, because I think that context is helpful. The National Center for State Courts is essentially like the trade association for state and local courts. We were founded a little over 50 years ago, and we are the secretariat of the Conference of Chief Justices and the Conference of State Court Administrators. And this is important because unlike the federal court system, which is all unified in one administrative structure, largely because there's one US Constitution, and so everything kind of flows from that. Because of federalism, each state has its own high court and its own structure of state courts underneath that. And so each state and provinces or jurisdictions have a state Supreme Court or its equivalent, and that chief is part of our governing structure. And it allows us to meet with and provide technical assistance and do research with state and local courts across the country. Zach and I work as part of a team within the consulting division that really focuses on how courts can better improve the experience for people who come to court unrepresented by lawyers, or who speak languages other than English as their primary mode of communication, or come to court with disabilities. And increasingly, especially with in the civil side of cases, there is an increasing number of cases with at least one side unrepresented by counsel. But just for context, there are about 100 million state court cases filed each year, and about 30,000 judicial officers that hear those cases. Those are in all different kinds of courts. So the blessing and the curse of federalism is that each state has set up their system differently. And so the cleanest example I'll give you is Alaska. There is a state Supreme Court, there is an appellate court, and there is a district court. It's essentially it. So if you file a lawsuit, you file it in district court. If you want to appeal, you appeal to an appellate court and on. But in Texas, for example, the map is really, really complicated. And there are two final courts of review. There's the Texas Supreme Court and the Texas Court of Criminal Appeals, which hears final disposition in criminal matters and one in everything else. And then it's the very complicated web from there. So our organization was really developed in an attempt to work with courts of various kinds to promulgate best practices and to support their development and growth. So let me take a pause for a second and see if Zach has anything to add about overview stuff before I keep going, because I'm just launching in, and it's probably a lot.
I love it. I know we're going to get to some of the stuff around filing systems and data collection and all those sorts of things. So I think keep going.
Okay. And I'm sorry, you all, I've come in hot at 2 o'clock with lots of caffeine. So if you, again, please feel free to interrupt us. So in this diversity of how courts are structured, part of a case is filed in court using a court record or a pleading documents, but then generate a court record which has all sorts of data in it. And depending on the case type, there is like different data that you can expect. The interesting and or not interesting, I don't know, thing about these court files is they're prepared by the parties, more or less. The court is kind of shuffling through materials that were shared by the defendant and the plaintiff. And so it tends to be whatever is required in the specific pleadings are what make their way into the court records themselves. So where this becomes particularly glaring, and we've had conversations with researchers in the past, is the issue of, for example, demographic information. It's very rare that a case document requires that information. And so it's very rare that that also appears in the court record, unless the court is pulling in data from law enforcement on the criminal context, which comes with its own complicated flaws. But it's very rarely asking the parties to complete that information for parties. So demographic information, as an example, is something that's not there. What usually is there is the name and address of the person, the people being on both sides of the case, especially the defendant, because they have to serve the defendant in order to comply with due process requirements. So you'll know where they are, their last known residence. And then there's the disposition of the case as it goes through court. It's usually all contained within the court record. Courts, the other kind of thing about federalism, I guess, that I would add is that because we have 50 different state courts, and then within those state court systems, there is diversity within those as well, how these records are maintained and shared varies widely. There are a handful of vendors that provide the backbone of a case management system in a lot of different state courts, but what data is collected and then what is publicly shared very much depends on the jurisdiction. Our organization, together with the Conference of Chief Justices and the Conference of State Court Administrators, worked to develop some national open data standards to try to get court systems from different jurisdictions to at least collect like data or define data in with using a similar definition, and then to report that data so that it can be aggregated at the national level. And we can I'll drop a link in a minute to the Court Statistics Project where you can see some of the data that is put available. In particular, some of the data that the conferences have been most interested in is how long a case takes from filing to disposition, the case type. In some instances, they're interested in different kinds of resolutions of those decisions. So was the case resolved because of a trial? Was it resolved because of a settlement conference? Was it resolved because of a default judgment? And so that can be reported. And that helps you understand how between those two, you can get some inference into kind of how participation is in some of these cases and how the way these cases get resolved. About 10 years ago, sorry, the National Center promulgated a best practice that you also count whether parties are represented or not, which is particularly interesting to Zach and to me, because we'd like to know in all of these case types how many people are doing this on their own or have lawyers. And because of that, we call it NODS, National Open Data Standards, we can now see in a bunch of different case types that the presumption is more than 80% of cases involve someone unrepresented by a lawyer in at least one side of each case, which tells us a lot about how courts should better prepare to meet the litigants that come before them. What else am I missing, Zach?
Maybe something about clerks and elected clerks and how that can change who owns the record and the data, and that gets complicated. Since we're with the data friends, we might as well talk some data, right? Yeah,
exactly. Different court systems operate differently. I guess that's the overall mantra of the afternoon. But who controls the court record varies quite a lot, and then how you gain access to it. So I, before joining the National Center, as an example, worked in the Illinois courts. And the Illinois court system is a particularly complicated example for purposes of data. because in addition to having 102 different counties, each of whom has their own kind of set of judicial officers, their own potential local rules and customs for what is required, each court, there is a judge or a set of judges, and there's also a separately elected clerk of court whose constitutional office is to be the keeper of the court records. So the judge doesn't even have the official court record. They have to get them through the clerk of court. And so you need the cooperation of both the clerk and the judicial staff in order to get access to records. In other jurisdictions, the clerk of court function is within the judicial branch, so it's a little bit simpler, and it just depends which jurisdiction you're in as to who you have to engage with in order to get data and to make those requests for information.
So one of the things Danielle mentioned is that we think a lot about the people who come to court without a lawyer. And we think about that because the number of people doing that is astronomical. Probably from popular culture, people hear the phrase, if you can't afford a lawyer, one will be provided to you. That's only true on the criminal side. So lots and lots of people are navigating these systems on their own. And as Danielle mentioned for our purposes today, the parties are the ones who basically initiate the filing, who respond to the filings, and are creating those data points within the court system. And one of the reasons that I think we're here today is because Amy and others know us from a little thing we do called Tiny Chats. We do lots of stuff that I would say is really important, but not all that much fun. And then there's Tiny Chats, which is maybe not that important, but really fun. It's our attempt to get some information out into the world in a way that is useful for courts, court staff, judges, advocates, lawyers, to help them think about how their system can better respond to those people. So we're going to get into some of the data stuff, but first I want to hit you with a whole bunch of links. These are to different Tiny Chats. And the one that I think might be of most interest to some of you is around AI-generated content. It's not data specific, but it's about how courts should and can think about what they're doing as it relates to AI-generated content, and how people who are looking for legal information and help navigating these processes are going to inevitably find a whole bunch of stuff on the internet. And whether that stuff is credible, good, or not is an open question. And so how do you as a court respond? And then there are a few others there where we're trying to encourage courts to adopt some practices. For example, using GIS mapping, layering in other data sources, so that when you're thinking about how do you best serve your community, you're not just relying on the data you yourself as a court system are creating and collecting, but also going outside of that. What's the most commonly spoken language other than English in my community? How should I then prioritize the translation of my forms so that people can navigate my system or my website? What about transportation time? How long does it actually take someone to get to court from most of my county? Is there public transit there? What are commutes like? So using those other data sources we think is really important. Next one is A to J data elements, and that is with our colleague Andrea Miller, and it's thinking about, in relationship to NODs and other sort of efforts to standardize, what kind of data could you collect to measure whether or not your court system is doing a good job providing access to justice, primarily for those people without lawyers. And then, of course, Amy joined us on one to talk about the Georgetown Data Commons. So those are just a few, and then the first link there is just where you can see them all. We've done a whole bunch of stuff. Some of that might be interesting to you, some of it might not. But now I want to talk about a couple of the tools we've built. But as Danielle mentioned, you should not feel shy about jumping in, asking questions, interrupting us, putting stuff in the chat. We'd love to just have a conversation. The first thing we started thinking about as it relates to data is, believe it or not, contracting and procurement, two of the absolute sexiest topics there are. Everybody's always going on and on and on about procurement. They go out to drinks with their friends. That's what they won't stop talking about. But it's important, right? Because how you procure and how you contract ultimately dictates the ways in which you use the technology that creates that data that we're all trying to get. If a court system, say, signs a 10-year contract with a case management system provider and doesn't do a particularly good job negotiating that contract or thinking it through in advance, they could end up in a situation where the contract doesn't provide who owns the data, or it might allow the vendor to access that data. And there might not be a problem with that, but there might be. And the court maybe hasn't given it all the thought they'd like to. If a case data isn't properly de-identified, could that be harmful? Could the vendor turn around and sell it? Could someone else access it? These are the kinds of things we think about in contracting and procurement. And to help with that, we partnered with a very smart guy named Sean McDonald. He works at the Digital Public is its name. He's the founder there. And we wrote a paper, which I'm putting in the chat, called Contracting Digital Services for Courts. And it's got examples, and it really helps you think through what should one do before you get to signing on the dotted line? How do you be mindful of those data concerns, those privacy concerns? And then there's a tiny chat there about procurement, featuring the joke that took us the longest to put together because I had to grow a full beard for like 2 months and then shave it off in pieces for your amusement. So I hope you'll check that out. The next thing we think courts need to think about as it relates to data and this whole process is transitions. When you're moving from one software or vendor to another, when you're moving from a system you built to one you're going to buy, when the vendor you've been working with for 10 years suddenly gets purchased by a new company, how do you manage that transition? How do you move from one to the next? And how do you do so in a way that's mindful of the data that's being created, being accessed, and that gives proper concern to privacy and security? And so we like to partner with smart people. So we partnered with a guy named Keith Porcaro, who's from Duke Law School. And we wrote this tool called Exiting Technology Projects, and a company Tiny Chat, of course. And what I like about these tools is that they're deeply practical. This is a website, it's a PDF, and it's even a booklet we'll mail to you. But what it is a series of exercises and thought experiments and checklists that help someone think through the process of moving from one technology platform to another with those data considerations, among other things, in mind, so that we're making sure that this doesn't present a problem that was I can't lost my words. So it doesn't turn into a problem that people weren't anticipating. There we go. We don't want people to get surprised. Thank you. Yeah. And then a couple other tools. One about sharing data. Maybe some of you have worked with court systems before. If not, I hope the overview that Danielle provided at the top was helpful in just kind of displaying what a complicated web it is. But something we've noticed quite frequently is that a lot of researchers who mean extremely well, and a lot of courts who mean extremely well, don't always know how to talk to one another about a data request. A court can be a very robustly funded large entity, or it could be a local, small, not so well-funded entity with very limited staff. So depending on how you ask for data and what you're asking for, the local court might say, man, I have no problem helping you, but I have no ability to do that. Or they might say, that'll take us 3 years. Or they might say, absolutely not. I don't have time to even think about this. I'm just moving on. That wasn't a request I know how to process. And likewise, for the researchers and academics and advocates who might want to access that data, I think it's really important that they know how to formulate that question in the right way so that the court can be responsive to it. We're big believers in sharing. We want the courts to share the data and we want people to be able to access it. But like anything else, it's knowing how to ask. So we built this tool, Court Data Sharing from scratch. And it likewise is built with Keith Porcaro, and it's a series of brainstorming sessions, questions, checklists. How do you work through the process of actually deciding what data to share and what data not to share, how to share it well with the identification and privacy rights concerns? And if you're an advocate, a researcher, an academic, how do you ask for that data the right way? And then the last thing I'll put in the chat, since I blitzed you all, are two of our favorite people joined us on a tiny chat. One's named Natalie Byram. She's from the United Kingdom. And the other's named Andrew Ferguson from Washington College of Law. And they both get into some big data thinking. What are some big data thoughts? Professor Ferguson in particular talks about the kinds of data that courts are creating and collecting and might not even realize that they are. You all probably think of lots of different things as data, but what's very common in the court world is for the court community to think of the stuff in our case management system as the data. And then there's other stuff. But a researcher might very well say, well, actually, there's lots of interesting data being collected in your remote hearing platform. When people log on remotely, we're learning a lot about whether they're joining from a PC or a Mac, from a phone or not, whether they're doing it on the road, whether their participation varies based on whether they have their video on or off. These are all important questions and can get to some really interesting kind of research questions. And courts not always thinking about it that way because they've been told for decades that the data is in the case management system, and now they're being asked to do all these other things. So Professor Ferguson does a really nice job thinking through a lot of that. And then Natalie Byram does a likewise nice job comparing this to the UK and some of the more advanced, I would say, privacy security concerns they have through the EU's data protection and other policies that are put in place that don't necessarily exist in every US state. So thinking about how courts can do a little bit better based on those comparative opportunities. So those are the things we've built. Those are the things we think about. Those are some of the people we've worked with and some of the people we've talked to on Tiny Chats. And what we'd love now, I hope, is to talk with you. You all know the data stuff. We know the court stuff. We kind of know some data stuff. and we thought maybe it'd be nice to just chat. How can we help you understand courts better? What kind of questions do you have about accessing data? How can we help?
This is Leah. Since no one else has asked me, I'll just go ahead and break in. Sorry for the background
Do
noise.
it.
I would like to be able to write a project where I can look at litigation related to condominiums. Do you think this is something that's feasible with existing court data?
Go ahead.
Oh, no, so I was just gonna ask a little bit more. So you're looking for any lawsuit that involved some litigation about the condominium itself?
Exactly. Like where the condominium association sues for unpaid fees, or sues the developer, or sues the neighbor, or any condo related litigation. I mean, I could think that I could narrow it to certain statutes that apply to condos. But is that anything is that like a searchable thing?
So, this depends on which jurisdictions you're interested in the researching and which case management system they have, and how much available data is there publicly, in order to do that. So the answer is it very much depends on the jurisdiction that you're looking in. One way
it's plausible that there could be a jurisdiction that would allow me to do this.
Yes, I would think so.
Yeah, I mean, depending on where you're looking and who you're looking at, one option that most courts allow is for a named party search. So, for example, there's a main owner of a area or a property management company or an investment firm that owns most of them. I think one thing that's probably likely to be offered anywhere is just being able to search by party name. So, Zach Corp, you go looking through there and you find all the cases that come up as a named hit. Would be one way to get there. If you're not so wedded to the US, the Canadians have a civil resolution tribunal that actually focuses on condo-based disputes. I just put the link to that in the chat. And that's kind of like an attempt at an alternative dispute resolution path. So rather than going through the formal court process, they route those kinds of complaints and legal issues through like an alternative mediation program. Another option would be, there are a couple parties out there that are collecting court data, like the Free Law Project. Most of their data is in the federal system through the PACER system. They have what's called RECAP, which is PACER backwards, where you can get all federal court records that have been downloaded through their platform. They store them for free for anyone to access. But they're also working on joining us in the state court world and are starting to collect case level data from court systems. Unicourt is a private vendor. There may be a cost associated with that, but that's another one that's collecting a lot of case law and has probably some more advanced searching functions that might facilitate a query like that.
Thank you.
Hope that sort of helps. Yeah, that's the best we got.
I have a question less about specific law related things, more about the process of data collection for different states. I don't work with legal data very often. I think listening to you guys talk about legal data, I'm very thankful for that at the moment. But something that I come across a lot is data around public utilities and the differences around states. So some states have statutes within their constitution on data collections, most don't. Where do you all see kind of the driver of data collection on the state side? Do you see that coming from the courts? Do you see it coming from the state itself? Where, if we're in kind of a data poor state, how might we be able to make changes within the state to further better data collection?
Allison, that is a really good and tough question. For example, I might, to begin, poke around in the court statistics project website that we gave you at the top and see if your jurisdiction has given any data to the national standard, there are like 40 plus jurisdictions that are sharing some data. So at least you have an opening. You can see what the jurisdiction which state court you're interested in, if they're participating in this national collaborative or not. And then a lot of administrative offices of courts now have a data person who works in a court system, and I might, depending on what you're interested in, if it's consider trying to reach out to that person. In one of the resources that Zach shared, the court data sharing from scratch, there's a page, I think it's pink, I can't remember, but there's a page in the middle that lists places where the court is subject to FOIA or not. So there is like a statutory incentive that requires states to share data in a lot of places, which is a start. Like this is the people's data in many ways. I think a lot of courts are increasingly sharing data. It's just a question of whether what they're sharing is what you want. And I think in many instances, when you go behind the curtain, the problem is less their lack of desire to share as much as either they don't collect what is actually useful to you, or they're not convinced at the state level that what they have is accurate. So they're not sharing it because of quality control concerns. So let me give you an example, which is probably more than you care to know, but at least it illuminates to me what I mean by kind of some of the data quality concerns by some underlying data. If you're in a jurisdiction where the clerk is a separate officer from the court, so there's a clerk of court who's keeping data, and you're also in a jurisdiction where each county or each circuit operates independently of one another, so then everybody can make different definitions of common terms, so what they're collecting can look different. So when I worked in the Illinois courts, I first got there and I worked with the Supreme Court to pass a rule: you must collect whether a party is self-represented or not. Do they have counsel? And I thought this was a totally easy request, Allison, and one that would tell me a lot of information. And the first go round, there were some jurisdictions that were reporting 130% of their cases had self-represented litigants, which is crazy. It can't be true, or 0%. And what it meant was, in some instances, every single person in a case, so if there are 3 defendants, each one was getting tagged, because like the definition was, despite the fact that we thought it was clear, the clerk wasn't defining it as such, or was treating it that you had to affirmatively file some special motion, which nobody does. So then it wasn't. So the fact that different decision makers are controlling the record can also affect reporting, which I think sometimes is one of the reasons working with courts is a challenge. But that's a rant.
Yeah.
So I don't know if that's very helpful.
Well, hopefully we're not scaring you off. I think another message I'd like to convey is that state court data is messy, and state court data is challenging to work with, but because of that, state court data is underutilized. People are not studying this nearly as much as they are, say, the federal courts, where things are a little bit more standardized and easier to access. I think another part of that question was sort of how can you encourage courts to collect certain kinds of data? Some of this happens legislatively, like anything else. So the legislature will dictate what sort of data might be collected in a certain case type. Some of it happens through court rule, where the local court or the statewide court system decides what kinds of data fields they're going to collect. And this goes back to some of that contracting and procurement stuff. An example would be if, say, in eviction cases, we'd like to know more about the racial makeup of the defendants in those cases. Are people of color being evicted at higher rates, or more subject more frequently to eviction filings? Right now, most courts don't collect that data. They don't collect that data because they're not asking for it. There are ways to get that data by asking, but a case management system, which has a bunch of fields and forms in it, might not have a place to put that. And so your court system that purchased this case management system 8 years ago and is contracted for another 5 would have to recontract for an update. And to do that would cost them, let's call it $100,000, $200,000, $300,000 to make all these changes along the way. So a court might be reluctant, not because they're unsympathetic to the request or they don't see the policy benefit. They might just financially not be able to do that. They just don't have the ability. So when we're encouraging courts to be thoughtful about their contracting, about their exiting technology project, that's part of it. let's facilitate the collection of that data and make it not such a challenge for the courts to actually do that.
And then I
I
just,
think
Chris
yeah.
had a question, and then I see
Sorry.
his hand. So starting with Chris, she asked in the chat about work with Superior Court specifically on research on evictions. And I put in response in the chat, this isn't an answer of the larger issue. I know the New America Foundation and several others have been kind of looking at, and Eviction Lab have been looking at data more widely. But what I'm really excited that our colleague Samira Nazem is working on at the National Center is we have an initiative that's working in 22 different courts across the United States to implement what we're calling eviction diversion. So it's a different pathway through eviction, and we've provided fundings for these courts to hire staff to help do that diversionary outreach. And as part of those 22 grants, the participating states are required to collect data about the eviction cases, which is different than what traditionally appears in the court file. And so it includes demographic information, why they're coming to court, what they expect to, what they want to get out of this court process. And the data that's coming back, we hope to have a first annual report by June, is really illuminating to me. It's helping us better understand what people want when they come to court and who is coming to court in a way that I have not seen data like that since. So I just wanted to make sure you were aware of that. And yes, the Bay Area has the eviction mapping project. So there are local pockets that have information. What I like about what Samira is working on is it's gonna get us information that would be really hard to access otherwise because it's direct survey work with litigants themselves.
That's great. Thank you so much, because that was definitely the other part of the question in working with typically policy students or who are working with cities who are trying to look at eviction rates or when they're changing their eviction ordinances. Again, in Bay Area, like East Palo Alto was having a real problem with this, but trying to get their hands on the eviction filings, even to track like the 3, 30, and 60 day, to understand what is the nature of that and who is being kind of targeted, because it was clearly a situation of targeting, and then trying to then step out and compare across other cities is always the challenge, but it is always the research question that happens. So thank you for this information. I really appreciate it. And really glad to hear that you're looking at the software systems. I work with government information and a lot of government data. And it's always been like, okay, well, what system are these cities and counties using, and what can you get out of it? Because that's really where we need to be looking at, because that's where we've got implication for how the information is being collected and then how does it get spit out. So again, thank you for all that work and talking about the procurement and systems work.
Certainly. Thank you for the question and good luck with the project. Keep us posted. All right, Leah, you're up. Thank you for waiting patiently.
Oh, sure, I already got my first question in. So on your court statistics page, you have this annual report that goes back to 1975. Now I skimmed that. It seems like 1975 is the first year they started making a report at all. Do you think there's any statistics that go back before that?
I'm happy to shoot a note, and if you put your email address in the chat, I can connect you with the director of the Court Statistics Project to find out. I'd like to think we have information before that, but if it's not on the website, I don't know what they collected. So I don't want to speak out of turn, but I'd be happy to connect you with. Her name is Dr. Nicole Waters, and she could tell you data beyond that. The National Open Data Standards is much newer than that. That was probably, I don't know, 2018-ish in time. And so until then, everybody was defining like terms on their own. And so the data probably before that is apples to oranges in some instances. So the conceit of NODS was to make sure that at least the data that you were comparing was defined in the same manner. And I'd be happy, Leah, to connect you with Nicole, and we can hopefully answer that question for you.
Thank you.
Sure.
I'm one of the listeners. I don't know how to raise my hand. Is it all right if I jump in for a minute?
Please.
All right. Hi, everyone. My name is Tom Bryan. I'm a professional demographer, and I'm an expert witness in political redistricting litigation. I used to work at the Census Bureau, and I work with data for court cases frequently. I'm happy to see there's some people on here who are colleagues of mine. David Van Riper from the Minnesota Population Center. For those of you who don't know him, is an exceptional resource for data, population data, especially what's called public use microdata that is used extensively in court cases around the country. There's two things I wanted to talk about just briefly. The first is that, we work with the census data, the U.S. Census Bureau extensively. And, they have a data platform called data.census.gov that provides demographic data. And, the challenge that even we as experts have is that even on those platforms, it can be very difficult to find the data, the questions, and let alone the data set and what you actually need in order to use in a court case. So a lot of the work that we do is helping people just figure out where and how, just training people and where and how to find the data, or helping folks get familiar with how to get data out of some of those very complicated and difficult data platforms. It is not easy. So I'll put a note here for those of you who want assistance or want, information on how do you better access census data, especially complex census data. That's something that we can help you with. The second thing I wanted to mention, dovetailing with the eviction case, is that in Virginia, there's an organization with a clever name called HOME, H-O-M-E, for, helping. It's a clever name for helping people basically that are impacted by evictions. And one of the things that they needed to do in order to file lawsuits to say that there were certain groups that were disproportionately impacted by not being given housing vouchers was they needed to say, well, how many of what kind of people are there? Minorities that are handicapped, single mothers, people that fall within certain income ranges, for example. And the only place that you can get that data are within those public use microdata that, David Van Riper is an expert in. It's something that we work with, because there is no place you can go onto the Census Bureau's website and just pull, a single mother with this income range and this disability, right? So those data are very complex and difficult to get at, but they are available, they are out there. And it's something that, there are people who provide those kinds of services, giving those data to help say, what percent of this very unique population is impacted by things like disproportionate allocation of housing vouchers. So those are my thoughts. Thank you for giving me a minute to share.
Sure, thanks.
Any questions or anything I can answer for anybody here before I jump off? All right, awesome. Thank you, everyone, for your time.
I don't see any other hands, so I'm going to take prerogative and ask a question. One of the things I noticed in, I forget which one of the resources you shared, but I think it was the court data, how to get started, is that the section at the end about protecting data, protecting sensitive data. And I was wondering, this is increasingly a concern across lots of different statistical agencies and lots of different data systems. Can you talk a little bit more about the kinds of things that that you're thinking about or that you're helping courts think about in protecting sensitive information?
Sure, I can take a start. Some of this is legislative, like things involving minors, for example, and sexual assault type cases or things like that. There's a public policy reason why you might not want to share that information, even though, as Danielle mentioned, court records are generally public. There are certain aspects of those that they do not want to share for very good reasons. Businesses also have an interest sometimes in protecting certain information, so they don't want that shown as well. Where it becomes a challenge for researchers and for policymakers and for us sometimes is when either litigants or the courts themselves are inadvertently over kind of classifying some information. We're working with a jurisdiction, for example, where in debt cases, the filing party, the debt holder or the claim debt holder, was required to submit evidence showing their ownership of the debt, and they were doing that, they were complying, but they were required to submit several kinds of documentation. And because some of that documentation contained sensitive information, they were clicking a box essentially in the case filing system that protected the entire file of all that evidence. And so for legal aid attorneys and for researchers and even for the court, it became a challenge to navigate that because they weren't supposed to be protecting all of that information. Some of it legitimately needed to be protected, but they were overdoing it. And so you had to work it through. And that one, there's like the policy part of this, and then there's the practice part of this. On the policy side, there's some very good reasons for that. Where we think, or at least where I speak for myself, where I see more challenges often is inadvertent use of tools or practices that maybe they're being overzealous, or that's just easier to click a box rather than to redact certain documents in certain places. And so that can present a challenge. But those are my initial thoughts. I'm sure Danielle has some too.
No, I agree with all of that. The only thing I would add is we have worked with courts in the past as they're developing. This comes especially with electronic filing or more robust online case management systems that you can search, similar to Pacer, although typically with kind of less functionality because they're newer. But as court rules where, to Zach's point, it was much easier to just kind of overprotect or put the entire onus because of the volume. Typically, the onus is placed on the parties to make those decisions, to be responsible for the redacting, and then to not kind of review in advance. And so some courts have gotten more sophisticated in their personal information rules. So to make sure, to Zach's point, that they aren't just protecting every single document, but they're actually redacting the sensitive part, but not removing the entire pleading altogether. But that requires a court willing to be that specific in what it drafts, and then also to review documents to make sure that that practice is not continuing. And depending on the docket and the jurisdiction size, like sometimes that is an institutional challenge to uphold. So it remains like a constant tension. We also saw, like to Chris's point, this was a debate that I think we've had for a long time about access to eviction records. So there's a public policy interest in seeing those records, but there's also a concern that once those are searchable in any format, that the tangible effect of being able to find out someone has had an eviction, like the sealing of those records, the tension of wanting to understand it, but also wanting to seal it to protect those potential future tenants from renting another apartment or house remains in constant tension. And so sometimes there are public, that also remains an issue for kind of policy to grapple with.
It's one of the reasons the Contracting for Digital Services paper I got excited about writing that, is because we were hearing about instances where a rightfully protected case file or a redacted document or information that was not supposed to be shared was properly redacted or protected or not shared. Yet the contract with the vendor hadn't specified what that meant for them. And so the vendor had the ability, per the contract, they weren't doing anything untoward, they were allowed to access this certain court data. So while the public couldn't access that protected or redacted or whatever not shared document, the vendor could. And so as part of that, they were selling data. And so things that were supposed to be protected from the public were protected from the public trying to access it through the court case management system, but not from the vendor, who was then selling it to a data broker, who was then doing all the things data brokers do. And so it was sort of circumventing that public policy protection. And that's obviously not right. And it's not something that the courts were doing on purpose, and the vendors weren't doing anything they weren't technically allowed to do. They were just collecting all the bulk data, and it wasn't categorized differently for them on their back end. So in that contracting process, we really want to emphasize, you've got to think about all of this stuff. If you're a court system, you can't just sign on the dotted line. You got to think about these eventualities and who has access to what and who has a right to do what and who has ownership of what and who can sell what. So you're all going to go out and become court data researchers, right? And you're abandoning your current projects, shifting your careers, you're immediately launching in, you're going right down to your main street, walking into the state Supreme Court, whatever it is. 97% of all litigation in this country happens at the state level. 97%. The feds get all the attention because it's centralized, they're big cases, and they're somewhat easier to use. But when you want to get where the action is, it is at the state level. But as you've heard, it's a little bit messy. Other questions? What do you think, Beth?
I was gonna say, I'm gonna ask one more for each of you, just because I'm curious. Like, you have come across some really fascinating things, and you've sort of touched on some of those throughout the talk today. But like, what's the most surprising? Like the idea that a vendor was selling data, so sort of surprising and shocking to me. What's the most surprising thing that you have come across in this work? I should have let you know I was going to ask this question before we got here, so you could think about it.
I'll tell you one that comes to mind, and it's an example of what happens when the thought isn't front and center about this data protection. There was a couple courts in the jurisdiction that was trying to play by the rules and be an open and accessible court, and so they were publishing eviction records online, so anybody could access them. Unfortunately, their case management system was connected to some criminal justice databases. And so if certain parties were in the criminal justice database, then when their eviction case files were posted on the public-facing website, the files included information, demographic information pulled from the criminal justice system. So while as researchers, we might sometimes want to know about some of that information for looking at public policy questions, in this instance, those people didn't know that would be up there. And so it was race, it was height, it was weight, it was all sorts of stuff. And the reason I found out about it is because a researcher actually reached out to us and said, hey, can you help us connect to someone at this court and let them know they might have a mistake going on here? And so we did, and they connected and they fixed it. But that one shocked me, that there would be this ability for this stuff to kind of connect on its own, and there wasn't that level of oversight that I would have liked to have seen. That's an example of something kind of going wrong, but there's lots of good examples too. I don't know. What shocks you, Danielle, besides working with me?
I'll give you a hopeful one. This is very like atypical. Usually I'm the downer and he's the upbeat one. This was an example of a court system using GIS mapping data in a really interesting way. So the University of North Carolina worked with a number of courts in North Carolina to try to understand why people weren't coming to court for their appearances. And then it was triggering bench warrants and a whole bunch of kind of collateral consequences. And what they realized was that all these courts had no actually meaningful public transportation to get to their court by 9 o'clock, that where most defendants lived, they mapped, and then they looked at public transportation availability to court. And in some instances, you just could not get to the courthouse by 9 a.m. unless you left at 6 o'clock in the morning and took 2 buses and a train and whatever else. And so some of it was just institutional. They set the docket at the wrong time and it was too difficult. So with remote hearings, making kind of Lyft and Uber tickets available to get people to come to court, they dropped their failure to appear rate by a pretty significant amount. So it was a way that a court used data not within their own, kind of using just a little bit of their own data, meaning trying to understand where their defendants typically resided, and GIS mapping to inform policy decision making that I quite like.
That is the most heartwarming data story I've heard in a while. So that is a delightful. I'm not seeing other hands, so that might be like the perfect story to end on for today, unless either of you have any final thoughts that you want to leave us with.
I think it's a great way to end it. And just know that we're here for you. If you have questions, further inquiries, we're happy to help. I blitzed your chat with all sorts of fun stuff, including us in costumes doing silly videos. So I hope you have fun with those. And thank you for having us.
Yeah, thank you both so much. And for those of you who are still here, just a little plug for in April, our webinar will be town hall format, and we'll be sending out an announcement about that soon. And then save the date, July 23rd and 24th for our annual conference. The theme is unlocking the power of public data, like we talked about, using transit data to improve court process. And that'll be at the Georgetown University Capitol campus in DC. We'll pop the link in chat for that. And then to stay in the loop for future events, sign up for our newsletter, and we will put the link in the chat for that as well. So thank you both so much. This has been delightful. I don't personally work a lot with court data, but now I'm more interested and want to learn more. So I really appreciate your time and all of your wisdom. Thank you so much.
Thank you for the
Thank
opportunity.
you.
Wonderful day.
Take care.
Take care, everybody.